I'd like to call to order the Subcommittee for Legal Affairs. In attendance is Councilor Daigle, Councilor Higgins, Councilor Melville, and Councilor Gamache. Would you mind sitting in for Councilor Turco? Sitting in for Councilor Turco will be Councilor Gamache. Item on the agenda, request to proceed to remove motion ordinance Gamache and entertainment license application structure from item with the request of land for 2 land. This subcommittee regular committee multiple times. I've heard numerous issues regarding where it was there was a about the land value is as the portion of Linden. I'd like to ask Mr. Bell to come up and just on new information.
Good evening, Kurt Bellavance. Yes, I believe at the meeting, appraisal, the as well as what the value of the portion that was in question would be valued at as well. So we, Dono and Associates was an appraiser that had recently finished the Central Street appraisals for the takings for that project, and they were currently working on the appraisals for easements in regards to the bike path, the Phase 1 project. So they were here, they were in Peabody. We thought they would be a good choice. They've done a lot of work for the city. So we asked them to take a look at this property as well. So they put their appraisal together. They came back. We had a few meetings with them to discuss the property. They came back. I know some people thought that the property would be assessed or appraised at a higher value. Because the city owns 3 different lots for zoning purposes, that they're combined. That's how the law reads. So, you know, it's not counted as an individual lot. So they looked at it as that was one parcel of land. And if the lot sat by itself, it wouldn't be a buildable lot. Not to mean that's not buildable area, but it's just not a buildable lot. So the appraisal came in less than we thought it would. And basically what they said is you would basically do the math and figure out, because that lot was 16,000 square feet roughly, and the value was at $33,000, that you would basically take that 4,100 that we were looking at and use the multiplier of basically $2.01 per square foot. And so the appraisal of that particular piece came out to roughly $8,300. So that's what the Dono and Associates found, and they provided an appraisal as requested. I'd be happy to answer any questions in regards to that.
Any questions from the council regarding Kurt Bellavance's explanation? Seeing none, I would ask anybody in the audience, and this under subcommittee rules, the chair is allowed to have anybody speak. At this time, if there's anybody in the audience that wishes to speak on this matter, I'd entertain that at this time. Just press the button, state your name for the record.
Is this the correct button? It is. All right. For the record, I just wanted to thank the chairperson, Mr. Rossignol, as well as the members of the subcommittee.
Please speak into the mic.
My name is Attorney Kenneth Schultz. I'm a lawyer in Lynn. I've been practicing real estate law now for 49 years. I was called upon by the Polignonis to review what has occurred. I told them that I would be glad to do that. The first thing that I did do is I watched the City Council hearing, which resulted in the motion, the final motion, to send this back out for an appraisal. I had an opportunity to listen to all of those that were present, including council members, abutters, and obviously Mr. Polignoni. My takeaway from that was that nobody was, in fact, receiving anything. There was just an unresolved problem that needed some new set of eyes. For that, I'm the new set of eyes, but I look at this that I was anticipating, ensuring that everybody was something. At the of the conclusion of the meeting, that not in a way constructive, is as follows. What I had seen was that the abutters were concerned. Oh, no, let me start. I thought the council was concerned that the which was an appraisal that Polignoni's was a suggestion that the property was worth than the appraisal that Mr. Polignoni is appraiser, which was $15,000. As a result, I suspect that everyone know was worth, as Bellevance indicated, the property was going to be more than the $15,000. I had a chance to look at the property. I have a pretty good understanding of the problems that were intrinsic to the property and its development, which was that the property, which was left undeveloped by the developer back 20-odd years ago when the property was developed, realized that the cost of developing this parcel due to the rock outcropping made it cost prohibitive. The property was then deeded over to the city. The city then decided to take a portion of this lot, which was the flat portion, and develop it into a park. I also heard from the abutters indicating that their concern was that the park was not being properly maintained. I heard that there were insufficient funds that were available from the city recreational department to maintain this good old park. The Polignoni situation is rather different. Their situation is they had anticipated selling their home and moving to a smaller home, and then it was determined by the buyer's council when they were running the title that a portion of their pool was on city-owned land. And that's what brought this to everyone's attention. I had a chance to look at the jacket, which is the building jacket, which was originally created when the application for the pool, I guess it actually predates that when the house was built, but subsequently when the pool came in. And the first thing I noticed was there was what's called a mortgage survey plot plan. That's when you go out and you get a loan. It's not a survey done by a surveyor, but at that time, back 17, 18 years ago, most building departments were more than satisfied with using those as a criteria for, in addition to their home or putting in a pool. Most building departments today are dissatisfied with that. They want a full survey. The other thing that was missing from that jacket was an as-built plan, which is now also required. An as-built plan is a plan that reflects what was done, where it was done, and it's done by a surveyor. That wasn't there as well. Now, going back and trying to justify an inadvertence by the Polignonis or an action by their contractor, their pool contractor, doesn't create anything other than innuendo and suggestions of impropriety. And clearly, no one would have invested $100,000 to develop that pool, which was the cost because of the rock that had to be removed. And there's also a wall there now, which is from some of that rock. No, to find out that 2 or 3 days later that it was built on the wrong spot. That was a terrible error that was made. It was an error that the Polignonis are now saddled with. It's a problem that we're hoping that the legal committee who had earlier heard this, as well as the council as a whole, will understand that the proposition that we're putting before the council will be a proposition by which we are willing to pay more than what it's appraised at. We're willing to pay the full $15,000 that was originally suggested. Where does that leave the balance? I'd like to And I don't know what I'm not sure how it's handled, but I'd like that balance to be applied towards the continual upkeep of that park. If that money could be earmarked to the Recreation Department for purposes of maintaining the park, I would think that that would be something that the abutters would find acceptable. Similarly, I don't imagine that the abutters want the property chipped or blasted and another house put in, because that would, A, take away the park, and it would be terribly disruptive. I think that the city could use these funds. Obviously, they can apply them any way they see fit. But right now, if anyone is familiar with the area, it's currently forested and it's rock, other than the small portion which has been identified for the parkland for the children in that community. We're asking the subcommittee of the council to reconsider what they earlier voted on, which was to move this along, a favorable vote, so a vote can be taken by the city council relative to the sale of the land to the Polygnones. As I said, what that would do is it would allow them to sell their property. It would allow some money to be placed into the city. It would allow additional funds, if the city saw fit, to apply them to the maintenance of the park, which apparently, or the playground, which apparently is in disrepair. I'm here to answer any questions. I spent some time trying to get a history, trying to look at this with fresh eyes, trying to find out how this may have occurred. They're more unanswered questions, but I can make certain suppositional guesses, which is how this happened. And my guess is, for whatever it's worth, is that the pool contractor, when he realized the extent of the rock that had to be removed, made some changes in the placement. I can also tell you that there are no markers that were ever found on that lot, which would indicate where the Polygnones property ended and where the city-owned land began. Unlike, and I heard the issue that came, don't your land ends and your land begins. It's not so easy in a case like that, because that rock doesn't show property lines. Polygnones had no idea, for whatever it's. If you're, there was an outbuilding that's on land, building that Polygnones bought. The assumption was, and they saw this outbuilding, which was theirs, which is local property, but own property. They just assumed, and they assumed that it was part of their property. Therefore, where the pool was located was inside of what was error. It's something that we'd have to go back close to unsort, but and the solution is, if the prepared as they were in a butter, who's in a situation, sure, it's somewhat self-created by the negligence of not the contractor, having it for the last 17 years and not being any of the water, needs relief, and he is seeking relief from the committee. I would ask you to entertain a positive vote, get out of your committee to the full council for a hearing, and I'm here to answer any questions that I might. My guess is that you've heard this tonight. I'm telling you something you probably don't already know. It's incumbent on me to do positive law in a way that everybody can walk away with a benefit, if at all possible. And I think this is, and I thank you for your time, Chairman.
Thank you. Anybody else that on this matter that already has been said? Just a name, just for the record.
Good afternoon. My name is Alan Titlebaum. For Emily, thank you for allowing me this opportunity to speak again. Own property to Linda Lane, Dale Farm Tot Lot property ID 1. Stand at the city some due diligence. So on a prayer letter that was emailed to each, but not formally allowed for record. I did not read with the question thoughts on how the land considered land owned by the city. Appraisal square foot take into consideration the amount based on 3 acres, and then next sentence state that the lot does not have enough frontage or is not big enough. This parcel we are talking about has over 16,000 square feet and is approved by the City Planning Board as a buildable lot. I would think I should hire Dawn Associates to appraise my lot, which is only 13,000 square feet, and the city appraises it for over $300,000. Think of the taxpayer savings if he reappraised the entire neighborhood in this cluster development with the undersized lots and without the required frontage. At this city council meeting on February 22nd, I stated that I was interested in the lot at 2 Linda Jean Lane. On February 23rd, the other applicant withdrew their request to purchase the city land. On February 27th, they applied for a permit for 27 Emily Lane for the demolition of a pool on city land 2 Linda Jean Lane. While this permit has been issued and is still active, they resubmitted their application for the 4,161 square feet of land again. I have since applied to purchase the entire lot. I will also say that I have a problem with the shape of the land that they requested presented this at the last council meeting. I feel that if they want to take land from the city should not be gerrymandering around the pool. It should be straight line as it was in one of their original plans presented to the council. I was told that they cannot be fined for cutting down trees as there's no accurate number of how many trees they destroyed. Why should the council be helping them with their negligence? Why should the city park land be odd-shaped to help the resident who has no regard for the property lines that they took city land, destroyed city trees, and removed city earth for their own enjoyment, and now will profit from it? They said that they say what they want you to hear. Hold them accountable. What message are you sending to others by setting this precedent? Thank you for your time and listening to me again.
Thank you. Anybody else wants to speak on this matter? Is there anything else different that you want to add?
I just wasn't sure if the subcommittee wanted a response to Mr. Teitelbaum's allegations and accusations. If not, if you've heard, I'm not going to repeat what I said earlier, other than this particular parcel, unlike other parcels that have been appraised in that area, which are developed parcels, which are flat land, which have utilities that can go to them, the cost of the development of this one particular parcel would exceed, because of the outcropping, any economic development that's going to go into that property on that lot. The only other thing that's of interest, and this was in the appraisal, is that this property serves only 2 purposes. It serves purpose that would to a conservation issue, and it's in there, or to the abutter. I'm not quite sure what the motivation of this other applicant is to buy the property, and I'm not going to go there. I don't think there's any purpose served by that, but there clearly is a purpose of leaving this property as is. As a matter of fact, as a result of any action taken by this committee, there'll be no change. The only change might be that the park itself is upgraded with the additional funds. All the trees that are currently there are going to remain there. The pool, if the subcommittee feels it appropriate, will remain there. It'll be part of the remainder of the pool, which is on the Polignoni's property, and it will resolve this issue. Thank you very much.
Thank you very much. Of the subcommittee. Councilor Daigle.
Thank you, Mr. Chairman. Thank you, everyone, for your feedback. And this is we spent a lot of time. It's really a tough decision for some, I guess white, but it's failed to get there. So errors on all sides, we need to stop pointing fingers. My opinion, and considering the opinion of constituents who called me and aren't here tonight, the city property and mistakes were made, and the best thing to do moving forward is to do anything in to go and enforce what happened and draw around what actually city property, give it back to the city. We spend all this money on open space. We're spending all our time on selling space to a mistake that was made. I think the resolution is just pretty much us doing nothing. I'm not sure that we have. I think that's in control. I think the building commissioner needs to go out and enforce with the mistake that we made. And so, you know, that's disgusting, but for me, and I have put a lot of thought into it. So I'm curious to see what the rest of the committee members say, and I'll speak up again if they change my mind. Thank you.
Anyone else on the subcommittee? Councilor Higgins.
Yes, I also have given this topic a lot of thought. When this first came around, I think I was on the committee for about, so I had a lot of look over all the work. I know this has been an issue for about a year or so, but the way I see it, it is, I don't even know how it works. We have, you know, rules and regs, and when I think a mistake was made, and I'm empathetic to the applicants for the mistake that was made. However, there's been other mistakes made in this city, and the resolution was to either move your fence, move your property. You can't just shrug your shoulders and mea culpa, I made a mistake. Now we have to help out. I'm in favor of keeping open space to the city. It's expensive. And that's how I feel about this topic. I feel we should just keep the open space.
Thank you, Councilor Higgins. Anybody else? Councilor Gamache.
Yes, thank you. I too believe that Councilor Daigle's suggestion is the right way to go. You know, she's correct, and the processes that are involved is once there's a excuse me. Once there's a situation that's been brought to the city's attention that those who are supposed to enforce should enforce, and that falls upon the building inspector's department. If we do nothing, the city's building inspector will go out there and issue a cease and desist that the property be made whole again, as the property line should be, and that the pool eventually have to be taken out in order to correct that situation. And I do feel for the Poliones. They you know, did try to come in here and do what they believed was correct and purchase the property, but they also took out a building permit to demo the pool shortly after the vote was made. And I believe it was the buyer who wanted the pool to remain on the site, and that's the reason why they came back to us. So I'm not going to say who's at fault or put blame on anyone. It's something that happened several years ago, and the city's got the ability today to correct the issue, straighten everything out. And unfortunately, the ones that are going to wind up having the most to do to correct the situation is the Poliones. Are going to have to put it back the way it was, whether it was done prior to them owning the place. But, you know, we have an obligation to the taxpayers of the city of Peabody to correct a wrong, and I think that's the only way we can do it. So I would be in favor with Councilor, I don't know if that was in the form of a motion by Councilor Daigle, but to do nothing would be to leave, and I don't know, I'd have to ask Don Kahn if we can do nothing, or whether we have to make a vote to deny or approve. And then if it's denied, the building inspector will be involved to go out there and issue a cease and desist, which is the way it should be. So if that's what you want in the form of a motion, I have no problem in making a motion today, right now, to deny the purchase for the city, for the property by the Pauleones, and leave it at that. And if that is approved, approved to deny, then the second motion out of committee would be to inform the building inspector to go out there and issue a cease and desist. So moved.
You heard the motion by Councilor Gamache. Any discussion on the motion? Seeing none, roll call vote.
Councilors Melville,
Yes.
Gamache.
Yes.
Daigle,
Yes.
Higgins,
Yes.
Rozignol.
Yes.
Motion carries 5-0.
Councilor Gamache.
Yes, predicated on the vote that was just made, I would make the motion, have the city clerk notify the building inspector tomorrow that the decision was to deny the sale of the property, and have them do their due diligence and go out there and do the legal processes that are involved to take that property back as it was already city property. So moved.
You heard the motion by Councilor Gamache. Any discussion on the motion? Seeing none, roll call vote.
Councilors Melville,
Yes.
Gamache,
Yes.
Daigle,
Yes.
Higgins,
Yes.
Rozignol.
Yes.
Motion carries 5-0.
Yes,
Councilor Gamache.
in hindsight, I would also like to move reconsideration on the first vote that was to deny the property. So move. Hoping same does not prevail.
I think that's a motion that we can save till the council of the whole.
Withdraw my motion.
Thank you. All right, second on the agenda is, need my glasses. Move to refer to Legal Affairs Committee, car carrier motion vehicle ordinance to include fines for the dealership that is receiving vehicles, brought forth by Councilor Gamache. Councilor Gamache.
Yes, thank you for taking this up in committee. I appreciate that, and I have Captain Richards here this evening, as well as City Solicitor Don Kahn, who I've been working with to try to resolve this. As you know, car carriers that are caught offloading or loading in the breakdown lane or any lane within the city of Peabody that creates a safety hazard are fined $1,000 by the police department. We do have a couple of businesses that repeatedly have not acquiesced to telling these drivers to pull onto their property, and so the only alternative that I think this board has is to create another part of the ordinance to fine the owners, individuals, corporations who are receiving those vehicles. And at great length with talking with Don Kahn and Captain Richards, I found out a few other little quirks that we have in this ordinance, and I'd like to address that, if I may, to Captain Richards first.
Captain Richards, if you may. Please.
Good evening. So we enacted an ordinance on 114 and Route 1 on the highways to cite car carriers that were delivering vehicles and stopping in the middle of the road. We've since enacted that ordinance, and we've been citing people for that, the operators of those trucks, and it has had an impact on the problem. But there are still violations taking place. So what we talked about and determined is the businesses that are receiving these vehicles don't seem to have any vested interest in getting involved. And the truck drivers are getting these major citations for dropping these cars off, and the businesses are not helping us resolve the problem. So one of the things that the council came up with is an ordinance that would allow us to be able to cite the business owners for allowing this practice to take place. The language of the ordinance is going to be obviously worked out with Donnie Kahn, because there were some issues about citing a business as opposed to a driver of a vehicle, and how does that work, and where is the appeal going to take place, and so forth. And we're working the bugs out of that now, but I think it's a worthwhile ordinance to send a message to the business owners that you can't just sit there and sit back idly and allow these violations to take place. when they're connected to your business and take no action to help resolve the issue. So I think this ordinance is going to help us do that.
Thank you, Captain Richards. And just a review for the council, the original ordinance stated that the car carriers could come to the city council to seek justification of the fine itself, which isn't proper, because when you do a motor vehicle violation, correct me if I'm wrong, they have the ability to go to court. And what we're doing this evening is to kind of strike an understanding that the car carriers are still going to have the right to go to court because it's a motor vehicle violation, and that's for the police department to issue. The next issue is that the owners of the property are now going to be able to appeal, but they will appeal to the city council, as we enacted in the original ordinance, that they would have rights to repeal at the city council. And this is primarily because it's a wake-up call. It's something that we're down to basically 2 businesses that aren't adhering to this, and they've had multiple infractions. And I have spoken to the managers of one of the corporations. It's like 4 times in the last 2 weeks, I had one on Route 1. So they're fluffing us off, and we figured maybe if they get a fine, I'm going to throw some landscaping because you can put vehicles on the lot right so high. Richard, I'd like to ask Don Connor a question. Cap. Don, thanks for tonight. We've spoken tonight, and I just want to have you give an overview to the frustration that we've received. A draft. What I'd like to see basically entails separating Section 1 to make a 1A, number 1 would be for the contract, 1A corporations or individuals that this, and then out of that ordinance, individuals pursuant to this section may request the hearing as follows: motor vehicle, car carrier violations make requests for a hearing because it's motor vehicle, and a corporation, individual, or other fined before the city council firm or remit the fine. Is that what we agreed to as far as what it be?
Yeah, the provision that the dealership vicarious is liable for the fact that the vehicle parked in the road by saying that they're not responsible. The new provision is going at vehicles, new loaded from a car carrier that's on the road. So the actual receiving vehicle will be a violation of the dealership. This is Chapter 90, a site issues, and it goes to court. So this will be a violation. Somebody wanted to appeal from the ticket, it would be a ordinance. It would automatically go to court, and it would be a different form later would receive. It would be a similar form to if there was a violation of health or building code. Chapter 90, violation of municipal form.
And if I may, we have spoken among Captain as well that the code enforcement officer, all know building inspector, therefore right away, and but a violation, a traffic violation, that would the notification that it went to that, and therefore the police, the office, to have them go and file an order violation for we've got basically everything covered right here. I think it's as quick efficient that we've had few and far between after this has been improved. People who receive the vehicles on, and there's only one that want to live. There's one on 14 that is in a that they pull into that, so that they have to lock them and drive in, and that's the safest way of doing it. And if they want that, they don't get fined. But if they want to park 114 and nobody from the business wants to go out there and tell them you can get $1,000. I think that's the only way we're going to be able to get this thing resolved.
One other point, Councilor Gamay, the participation of police officers proceeding would advise their observations of the violation if there was hearing before the council. They would be performing an evidentiary function.
I have no further.
Thank you.
Councilor Gamache, do you have language that you want to introduce the motion?
Yes, I do. Unless there's questions.
Does anybody have questions? Councilor Daigle.
No question. Thank you, for my work. I know you've spent a lot of time on this, and I know that it will be an educational for the police to come and learn to call the proper report that's referred and system to us. So I appreciate that, because I trust you're going to help with that educational. I'm completely supportive, so thank you.
Any other council speech?
Thank you, Mr. Chairman. When we first discussed this, I was under the impression that we were creating this for state highways. And I had brought that up as we were doing motor vehicle class license. Now we have a lot smaller. Our downtown have been here for decades at this point, long, and I've and my concern is we're now notifying them of this new ordinance, and to my knowledge, council speak whether these things have issues with these smaller areas. I understand, like on Route 1, on 14, like especially 114, we're dealing with like brand dealerships. We're not; these aren't used for the most part. And the concept behind it was safety, especially on a state highway with multiple lanes of traffic, either using the breakdown lane or the turning lane on 114. Obviously, it's a significant safety issue, and I guess I would ask a question through the chair, if only identifying state highways within the ordinance makes it unenforceable or makes it challengeable by law in some sort of way that we're targeting certain certain highways, or if there's some legal reason we would need to enforce this across the entire city.
Thank you. That's a good question. Actually, the way the ordinance, the new change is drafted is it would only apply to parking in a breakdown lane or parking in a travel lane. So if someone was delivering to a small business and they parked on the side of the street, as long as they weren't obstructing the travel lane, then I don't think they'd be in violation of the ordinance.
Thank you. And I would, I guess, follow up to Captain Richards through the chair if that explanation is something that makes sense from a public safety standpoint, from an enforcement standpoint for officers that highway down lanes, travel lane, on the side of Margin Street.
Difference. Down lane is clearly ways. Side roads may have a fog line. There's no breakdown there. The only issue that we would carry up and literally travel and interrupt the traffic, that would be a violation. that would be something we would have to. So, people, we know that some of these car dealerships take now and then, and if we're not getting complaints, it's not backing up traffic and causing problems, then there's really nothing to address there.
Thank you. I think that is my concern. Just thinking of the few ships that I know that will occasionally take carrier. We're not cars at a time. I do see that pulled off to the side on a road. It doesn't cause issues. It doesn't. And I just want to make sure that we're not trying to on issue for those businesses at the same time. Thank you.
Chairman, I'm not on. Appreciate you letting me comment. I just want to the. This first came up kind of with a small deal that Council Peach referred to for was transferring on Foster Street, and interestingly, I had a number of meetings with that owner, and 2 out of the 3 or 4 times that I was down there, there was another used car dealership on Foster Street taking deliveries from with utilizing full-size car carrier and in the public way and obstructing a lane on Foster Street. So just to be clear, that continues to be a violation under this ordinance. Is that correct? Is that I see some nodding here, but I mean, if that's not the case, then I would definitely have a problem with this. If that is the case, then we need to be certain that condition can't exist, because we all know that certainly at particular points in time in the day, traffic is already bad enough. So if we're sticking a car carrier in there first thing in the morning, it's a major problem.
Captain Richards.
The scenario that you provided is a violation. It would continue to be a violation. Even though there's no breakdown lane there, if there's a full-size car carrier on Foster Street blocking the lane of travel and impacting traffic, that would be a violation under this ordinance.
Thank you. It's a relatively occurrence. So some of these licenses, they have a number of cars, but there are that go around and for cars, small dealerships on large carriers. So although they're small, they are utilizing some of the large carriers. So I think it's appropriate. Captain Richards, if you could step back up for a second. In your department's review of these licenses, I know Sergeant Harkins has kind of pointed out that he's looking to understand what their plan is to accommodate vehicle delivery, and I hope we continue to do that with all dealerships, regardless of their size. Would that be your intent?
That would be, and as part of the plan of any new dealership or any dealership renewing licenses or applying for special permits, one of the things that we should be asking is, what is your plan to have vehicles delivered and picked up at your dealership? And if they don't have the size property that accommodates that on the property, then we really need to make sure that if we're going to grant the permit, that they have an off-site place that they can go to pull the truck in and transport the cars back and forth, so that they're not interrupting traffic and causing all kinds of problems.
Right. Thank you, Captain. I mean, I'm fine with the change as long as that continues to be the case, that the police department on the front end of all these things is requesting that plan, because otherwise it's going to be kind of catch when catch can. Thank you, Captain. Thank you, Mr. Chairman.
Thank you, Councilor McGinn. Councilor Peach.
Thank you, Mr. Chairman. Just not necessarily about this ordinance, but in the discussion that comes after implementing this, when we have these on transfer dealerships, I would ask if during our full meeting would or if I would do it under your report, to get an opinion from the building on what zoning our storing of cars allowed? Like where, when someone comes to us and says, well, I have this contract with this company and I'm gonna have my cars delivered there, and then I'll bring them to my lot, I'll drive them across the city with a dealer plate. Like, is that allowed across any zoning? Is that, like, how does that work? I'd like to have an opinion, so when it comes up again, I wouldn't want to be like, oh, I meet the car in the mall parking lot and we offload it in an empty parking lot and then we move forward. I don't think that's a great plan.
Councilor McGinn.
Thank you, Mr. Chairman. Through to Council Peach, I think after that first hearing, a motion along those lines was made. As you may recall, the location was Pulaski Street, and I think Councilor Turco made a motion that kind of captured the spirit of what you're asking. I just don't think we've seen a response yet, so I think it's out there already.
Councilor McGinn, you are correct. Any further comments from the council? Councilor Gamache.
I want to thank the council for a lot of good suggestions that came out of this. I think Captain Richards has basically said they're going to use common sense in any areas that are not highways. As long if they are obstructed, then common sense prevails. And as you know, towards that they deal with this, your semi-frustration because it does traffic. Department will have to. But I want to thank everybody's input. If I may, I'd like to make under Section 1, the Code of January 1996, and amended hereby further amended by creating 19-48 entitled Article 2 as follows. I'd like to, number 1 specifically says, no by motor vehicle shall stop or off breakdown lane within. I would like to insert 1 that reads, shall accept motor driven by a car stopped or offload within a travel breakdown lane located within a public. The issue of the ownership of the other one that I section violation of this ordinance punishable by a fine of $1,000 and a fine of $1,000 for second offense. 3, to have it individuals or pursuant to this section may request a hearing as follows. Motor vehicle, car carrier violations can make a request for a court hearing, which is the law as it exists today, and also for the businesses of the vehicles that are being delivered to, corporation, individual, or other entity fined may request a hearing before the City Council, which may affirm or remit the fine. So moved.
You heard the motion by Councilor Gamache. Any further discussion on the motion? Seeing none, roll call vote.
Councilors Melville,
Yes.
Gamache.
Yes.
Daigle,
Yes.
Higgins,
Yes.
Rozignol.
Yes.
Motion carries 5-0.
Thank you. Moving on to our third and final item, a motion by Councilor Melville to refer to Legal Affairs non-live entertainment application. I'd now entertain a motion to receive late 2 as well as 8E.
So moved, Mr. Chairman.
You heard the motion. All in favor? Any opposed? It's a vote. Councilor Melville.
Thank you very much, Mr. Chairman. So this originated, this motion originated when we had a number of non-live entertainment permit hearings that came up, and I know there were a couple things. First, that sometimes one of them we could approved because the person wasn't in the, they were doing it remotely. Additional, there's another one. They had some of the individuals were hiring attorneys to come here. Pretty straightforward hearing where we're glad to have your business. There wasn't much. Notice that as a trend in these non-entertainment. I want to be clear. The issue discussed live. So live entertainment would still fall currently in place. Would go non-live, like TVs and radio. I just looked at it as a burden on essentially operating, and we're that they had to get government. Additional to that, if you remember in January, we started adding additional fees not for license and permit and additional to that, for further research, something we're actually going folks maybe show TV videos. So the folks that are getting for something. So I want to thank, you'll see that we have 20 outstanding non-live entertainment permits in the city. I think we can all agree there's probably more people operating as if they have non-live entertainment than 20. But additional to that, it was, I asked the clerk to put together a list from some of the other communities, and you'll see, like, for example, Beverly has no fee. Other cities and towns have fees and whatnot. Now, I want to thank Councilor McGinn as well. I talked to about this issue, and I did some research as well. And I can add this as part of the packet for, because I'm going to make a motion today to get just some further information on it. That there's a lot of state statutory requirements that go to these non-live entertainment permits. Now, there's a question on fees, whether we even need a fee. As you can see, Beverly doesn't have one, or process, so issuing them. Do we need to have a hearing to issue these particular permits, or could the clerk just issue them? And that would be, you know, that seems to see the leeway that's with the municipalities regarding this issue. I would make a motion, and I'll hold off on this motion. I wanted to get some feedback from my colleagues so that we can get further information if anybody had it. But my motion to the City Solicitor's Office would be to get an opinion of, is a public hearing and an opinion of the City Solicitor's Office regarding non-live entertainment licenses limited to TVs and radios, to such process for issuing such licenses, public hearing requirement, a notification of a butters requirement, advertisement requirement, and fee requirements, and what options the council would have to limit or reduce those. And so that would be the motion that I would make. I already spoke to Attorney Khan. He'll have to do some research. There's some state requirements on this. So that would be the motion I'd make later. I just wanted one more comment on the fee. So it's a $50 fee. However, there isn't a butter notification requirement and advertisement requirement for the initial application. So the fee might be $50, but it can be somewhat burdensome if, say, you're in a dense neighborhood or near the mall or something along those lines. And I have heard from attorneys in the past who have commented on some of that with locations and saying, I'm just going to have TVs and radios. So I wanted to bring that before the council and the committee to get some opinions, and I'll make that motion once we conclude. Thank you.
Thank you, Council Melville. Any councilors on the committee with any comments? Councilor Daigle.
Thank you, Mr. Chairman. My only feedback, I thought live entertainment is usually associated with alcohol, and that's when it's triggered to get the permit. But I would love to streamline this process so that businesses that are trying to open and turn on a TV or a radio aren't going through one more process, and whether it's they just go to the city clerk and file, or they just don't file at all, I'd like to see it easier for everyone and have one less step for them for something that seems common sense. And if there's a problem, then we can enforce it and deal with it. So that's my 2 cents. Thank you.
Before I go to you, Councilman McGinn, my only feedback on this matter is outside entertainment would, in my opinion, be secondary, because I think that that's a completely different matter than a TV inside of an establishment. And then the other thing is, and this I'll actually pose to the council as well, if you look at an establishment that is their live entertainment basically is TVs, whether it's, I'll just say Tony C's for that matter. Their draw is a mass quantity of TVs, whether we wanted them to have a license for that type of operation. That's the only two questions I had to the council when we're looking at this amendment change to the ordinance. With that said, Councilman McGinn.
Thank you, Mr. Chairman. I just wanted to applaud Councilor Melville for his efforts on this. Based on what I have seen in Mass General Law, I think there is some room for us to simplify this process somewhat and make it less burdensome from a cost perspective. So I appreciate you being persistent on this one, Councilor, and look forward to the response that we get back from the city solicitor. Thank you, Mr. Chairman.
Thank you, Councilman McGinn. Any further discussion on this matter? Seeing none, Councilor Melville.
Thanks. Yeah, I'd like to make a motion to request from the city solicitor's office a memo for the options the council has in the process of issuing TV and non-live entertainment permits to be limited to TV and radio, and such requirements for such permits as public hearing, abutter notification, and fees. So moved.
You heard the motion. Any discussion on the motion? I have one question. Could you just add the word indoor non-live entertainment?
Absolutely. Please amend my motion to indoor. Thank you.
You heard the motion by Councilor Melville. Any further discussion on the motion? Seeing none, roll call vote.
Councilors Melville,
Yes.
Gamache,
Yes.
Daigle,
Yes.
Higgins,
Yes.
Rozignol.
Yes.
Motion carries 5-0.
Motion to adjourn.
So moved.